Ms. Lynch is the real thing. Thank you.
Thank you very much. Now, Professor Legomsky.
Thank you, Mr. Chairman and honorable members of the committee. Thank you for the privilege of testifying this morning. I'm here to focus on the concerns that some have expressed about the President's recent executive actions on immigration. I do sincerely appreciate that reasonable minds can and do differ about the policy decision as to precisely what the enforcement priorities ought to be. But I want to respectfully share my opinion that the President's actions are clearly within his legal authority. That is not just my opinion. 135 immigration law professors and scholars signed a letter just this past November expressing that same view in strong terms. This is the mainstream view among those of us who have spent our careers teaching and researching immigration law. The President has not just one, but multiple sources of legal authority for these actions, and I've submitted a detailed written statement that documents each of these. The written statement also identifies every legal objection I could think of that the President's critics have offered, and it explains why, in my view, none of them can withstand scrutiny. So with limited time, I'll hit just a few key points and refer you, please, to the written statement for all the other points. First, I think all now agree that in a world of limited resources, prosecutorial discretion is unavoidable. You can't go after everyone, so you have to prioritize. In the case of immigration, Congress has made this explicit. It charged the Secretary of Homeland Security with, and I quote, establishing national immigration enforcement policies and priorities. That alone would seem to suffice, but in addition, year after year, Congress knowingly gives the administration only enough money to pursue less than 4% of the undocumented population. That, to me, is the clearest evidence possible that Congress intends for DHS to decide how those limited resources can be most effectively deployed. In fact, Congress has specifically required DHS to prioritize three things: national security, border security, and the removal of criminal offenders. And those are exactly the three priorities that these recent executive action memos incorporate. On top of all that, we have the 2012 Supreme Court decision in Arizona v. U.S., where the court struck down most of Arizona's immigration enforcement statute precisely because it would interfere with the federal government's immigration enforcement discretion, which the court went on at some length to emphasize the breadth of. Now, some critics claim that if the recent executive actions are legal, then that would mean there are no limits at all, and therefore some future president could suspend enforcement of some other law. But DACA and DAPA don't even approach the sort of hypothetical non-enforcement that argument conjures up. I think that if the president were to refuse to substantially spend the resources Congress has appropriated, then I believe we would have a serious legal issue. But that's not even close to the present reality, because even after DACA and DAPA are fully operational, the president still will have only enough resources to go after a small percentage. And so as long as he continues to use those enforcement resources that Congress has given him, it's hard for me to see how that could be called an abdication. As for deferred action specifically, the program has been around for more than 50 years. Not only has Congress never acted to prohibit it or even restrict it, Congress has affirmatively recognized it by name in several provisions. The formal agency regulations also recognize it by name. A long line of courts, including the Supreme Court, have recognized it by name. Not one of these legal authorities, not one, says or even intimates that it's legal if it's a small number of people, but otherwise not. The same is true for work permits. The statute authorizes DHS to grant permission to work, and the regulations specifically make deferred action recipients eligible for them. Now, some have said deferred action is okay on an individual basis, but not for a whole class. First of all, nothing in the law actually says that. And in fact, almost every modern president has granted reprieves from removal and work permits to large, specifically defined classes of undocumented immigrants. At any rate, the Secretary's November memo is filled with clear, careful, repeated instructions to officers that even if the general criteria in the memo are all satisfied, they still have to make individualized, case-by-case, discretionary judgments. And in fact, the very form that USCIS officers are required to use when they deny deferred action, and they've denied it more than 32,000 times on the merits, contains a list of the reasons, and one of those specific reasons listed is discretion. I think this is the way an agency should work. It articulates general criteria and then expects its officers to use some judgment in applying those criteria to individual cases. Thank you very much for your time.
Professor Rosencrantz, briefly, if you don't mind, do you agree with that, that we are at, I think Professor Turley once said, a tipping point in the question of executive and legislative power, and it's a matter of grave importance to the Republic?
I think it's certainly a matter of grave importance, and I think we have seen dramatic examples of executive overreach in the last several years, things that are unprecedented, things we've never seen before.
Well, and do you agree with Professor Turley that one of the most significant overreaches is the President's executive actions with regard to amnesty?
Yes, I absolutely do. I think it's inconsistent with his obligation to take care that the laws be faithfully executed, in particular the Immigration and Nationality Act.
Well, it seems to me that they're arguing that take care that the laws be executed means you have to do the best you can to enforce the laws under the circumstances, which has some legal basis. But in truth, don't they go well beyond that and create whole new laws that not even on the books? They're not authorized to do that, are they?
You're quite right. This action looks a lot more like a legislative action than like executive discretion.
Senator, may I jump in and comment
Yes.
on that, please? Thank you. We've heard a lot of very broad general statements to the effect that separation of powers is important, which of course it is, that the President is not above the law, and of course he is not. But I've yet to hear any specific rebuttals to the points that I was making earlier about the specific sources of authority that Congress has provided. We do have this legislation which specifically says it is the responsibility of the Secretary of Homeland Security to establish, quote, national immigration enforcement policies and priorities. And not only that, but Congress has specifically directed the administration to prioritize three things: border security, national security, and the removal of criminal offenders. And those are precisely the priorities reflected in the recent executive actions.
Well, I appreciate that, but I don't agree. Congress laid out.
Senator Blumenthal.
I really appreciate that, Mr. Chairman. And,
My apologies for the error.
Like our friend Senator Sessions, I applaud your meteoric rise within limits.
Thanks for the clarification.
But thank you for your courtesy and your deference. I'd like to ask Professor Legomsky to expand or explain a little bit why the examples involving enforcement of the speed limit may not be really an exact or valid comparison to what we have here.
Thank you, Senator. I think it's a fair hypothetical to throw out, but I definitely feel that there is no simple answer, mainly because there are two pieces of information we would certainly need. The big thing is that every statutory structure is different. And so the first thing I would want to know is, what does the state statute say? How much discretion does it actually give the executive branch to set highway safety priorities? In the case of the executive actions we're comparing it to, for example, again, as I mentioned earlier, Congress was very specific. It gave the Secretary the explicit authority to establish national priorities and policies, and in addition even indicated what those policies and priorities are. In addition to that, the other point I would make is that it matters what the particular priorities are. They have to be rational in one way or another. I think most Americans, if asked, would say the President's priorities look like pretty much common sense to me. He's prioritizing national security, border security, and the removal of criminal offenders over the destruction of American families, the destruction of long-term community ties by people who have otherwise lived peaceful and productive lives in the United States. And since you can't do everything because the resources are limited, those strike me as reasonable priorities. So I would ask the same question with respect to the speed limits. Has the governor made a reasonable
maybe
choice?
the comparison would be more like the governor of Utah deciding that on a flat straightaway in the middle of the state, that going over the 65-mile-an-hour speed limit would not be enforced unless the person was doing something in addition dangerously, like weaving back and forth, but in more congested areas that the 65 speed limit would be enforced rigorously. In other words, defining other characteristics, not just saying we're not enforcing this law.
I think that's an excellent point, Senator, with all respect. And that is very analogous to what the President has done with his recent executive actions, because, as you know, both the prosecutorial discretion memo and the recent DAPA memo draw all kinds of fine gradations, and that, I think, accommodates the point that you were just making.
And just to clarify, there has been a suggestion that the President's exercise of discretion does not permit case-by-case decision-making. In other words, that it is a broad, across-the-board exception for all cases. But in fact, what the President's doing is really an exercise of delegation of discretion, prosecutorial discretion, for case-by-case decision-making. Is that a fair characterization?
I think that's a very fair characterization. I'm thrilled to have the opportunity to answer that question, because that's something that has concerned me a great deal about some of the criticisms that have been offered. The Secretary's memo says, not once, not twice, but over and over again, that officers on the ground are instructed to look at the facts of each individual case, to evaluate them on an individualized basis, and specifically to exercise their discretion. Not only that, but as I mentioned this morning, the form that the USCIS adjudicators are required to use when they deny a DACA case lists the possible reasons for denial, and it specifically lists exercise of discretion. There was one other thing I was going to mention, and that is that if anybody doubts that these instructions are actually being obeyed, more than 32,000 denials have already occurred on the merits. This doesn't count things that are rejected at the lockbox for failure to pay a fee. These are actual denials on the merits. And I must say, and I hope this doesn't sound snarky, because I really don't mean it that way, that I worked at USCIS for 2 years, and I can assure everyone in this room that the USCIS adjudicators are not a core of open borders advocates who are looking for ways to systematically disobey the Secretary's explicit instructions. They take their job seriously, and they do exercise the discretion that the Secretary has told them to.
I appreciate that clarification. Of course, I would invite any of the other panel members to disagree if they wish to do so.
Miles an hour. I assume he means a straightaway on an actual state road. But there is a difference between deciding not to post a police officer there and issuing a permit saying you may exceed the speed limit, and if you're caught going, up to 75 miles an hour, even though that's in excess of the lawful posted speed limit, you will not get a ticket. There is a distinction there. There is, moreover, the fact that another hypothetical question that I brought up that I was disappointed that she didn't agree to address head on was one involving a hypothetical future president, maybe a Republican, maybe a Democrat, I don't know, somebody who decides, you know what, I don't like our top marginal tax rates, and I think it's morally wrong to enforce a marginal tax rate above 25% at the top marginal rate. So I'm going to issue a series of letters to people who request them saying you can pay at the 25% rate and no higher, and nothing's going to happen to you. I agree, moreover, Professor Legomsky, that something more like the answer that you provided would have been helpful. I didn't have even that, and had she provided that answer, we could have then gotten into a deeper discussion about whether or not Congress has in fact done this, and whether or not Congress did in fact, based on an analysis of the text, create something that could create an exception to allow many, many millions out of the, 11 or 12 million people who are estimated to be inside the United States illegally. Did Congress really create something that could create an exception that potentially swallows the rule or comes very, very close to it? Let's turn now to Professor Rosenkranz. You haven't had a chance to chime in.
I want to shift to a different set of issues, which is the pattern of lawlessness of this administration. And I want to focus on a line of inquiry that we had yesterday with Ms. Lynch concerning prosecutorial discretion. And I want to address this question to Professor Turley. Let me say, Professor Turley, I commend you for having the courage to speak out about your concerns about the constitutional dimensions of the conduct of the executive. I recognize that has not been easy for you to speak out, and I suspect you have heard more than a little grief in the faculty lounge for having done so. So let me say thank you for having the courage of your convictions. I wish we saw a lot more members of this body with similar courage of convictions. Yesterday I asked Ms. Lynch if she agreed with the reasoning of the Office of Legal Counsel that under the theory of prosecutorial discretion, the administration could decline to enforce immigration laws against 4 to 5 million people in a categorical manner, and beyond that could affirmatively issue work authorizations, print documents that purport to authorize them to violate federal law and work in direct contravention to federal law. Ms. Lynch said that she found that OLC reasoning persuasive. Do you agree with that assessment?
I have serious problems with the reasoning for a couple of reasons of my own. First of all, much of what we do when we look at separation of powers is to look for limiting principles. We're in a system of government that is shared and limited in its nature. And part of the problem that I have with the administration's position on things like immigration is that it lacks that type of limiting principle. To respond to my colleague, who I have a great deal of respect for, I don't see this is a matter of discretion. First of all, I'm not too sure if it really does mean what my friend said, why they bothered even saying it, because that would make it just a standard prosecutorial discretion of people who are boots on the ground. I don't know why you would even issue this if it meant what my friend has said. But second, if you look at that letter from immigration faculty, as I did, once again, it raised this issue. What's the limiting principle? The letter seemed to suggest that as long as you're deporting one person, everything before that point is a matter of discretion. I can't believe that could possibly be true. If that were true, then virtually any law could be shut down except for one case, and you could claim you're just exercising discretion. I do criminal defense work when I'm not teaching, and I think if I went to a prosecutor and said, look, I'd like you to basically give my guy a walk because this whole category that he's a member of really shouldn't be subject to this type of enforcement, I think most would look at me like I had two heads. They certainly wouldn't give me much help on that. There is a legitimate question of prosecutorial discretion, but this is not one that I recognize. But my concern really as a constitutional scholar is if this is prosecutorial discretion, I don't know what would not be prosecutorial discretion. And this notion that is developed from prosecutors, is not obviously in the Constitution, would swallow the obligations of the president. Any discretion that my friend talked about in terms of setting policies and priorities has to be defined within the context given to the administration by Congress.
Well, Professor Turley, I very much agree, and my time is expiring, but I want to ask one final question, which is I agree with you that the question is where do you draw the line? If the president can, through discretion, simply refuse to enforce a major portion of immigration laws as it concerns millions of individuals, what other laws can the president unilaterally refuse to enforce? And yesterday I asked Ms. Lynch about a couple of examples. Number one, could a subsequent president instruct the Secretary of the Treasury, do not collect taxes in excess of 25%? And number two, I asked, could a subsequent president instruct the Department of Labor, you shall not enforce any of the federal labor laws on the books against the state of Texas. The state of Texas is hereby immune from every federal labor law that has ever been passed. To both of those hypotheticals, Ms. Lynch refused to answer, refused to say what I think is the obvious constitutional answer, which is, of course, a president cannot do that. And so the question I want to ask Professor Turley, and I want to give an opportunity for everyone in this panel, anyone on this panel who wants to engage, does anyone on this panel disagree that it would be unconstitutional for the president to refuse to enforce the tax laws or the labor laws or the environmental laws? And if you think that would be unconstitutional, does that not necessarily lead one to the conclusion that the president's executive amnesty is likewise unconstitutional. Professor Turley, if we could start with you.
Well, I believe those examples would be unconstitutional if the president claimed that authority.
I actually agree with both Senator Cruz and Senator Lee that there is a difference between saying we simply will refrain from prosecuting and saying we will give you deferred action and a work permit. But on the specific question that you've asked just now, I do think that a decision to not enforce the entire immigration laws or not enforce the entire tax laws would clearly exceed the president's legal authority. But that's not even close to what we have here. As I mentioned a moment ago, even after these new policies are fully operational, there will still remain in this country at least, and this is a conservative estimate, 6 to 7 million undocumented immigrants to whom these policies don't apply, and the president still will have only enough resources to go after fewer than 400,000 of them, which means that nothing in these policies will prevent the president from continuing to enforce the law to the full extent that the resources Congress has provided.
Let me briefly ask a clarification on your example. The reason you said the executive amnesty is constitutional is because there exists some substantial subset of people against whom the laws are enforced. Well, let's take the labor law example. If Texas were exempted, there'd be 49 states, a whole bunch of people you could enforce the labor laws against. So would that satisfy the test you've just put forth?
If I understood the hypothetical correctly...
Hang on just one second. In the interest of time, after he answers this one, we're going to have to turn to Senator Franken. We've got votes coming up, so we've got to keep moving. Thank you.
I'm sorry. I just want to make sure I understood the hypothetical correctly. In your hypothetical is the president enforcing the law in one state but not in the other states, or vice versa. One of the limitations, I think, is that the particular priorities have to be rational. And I think that discrimination against the residents of one state would fail that test. Along the similar lines, my friend, Mr. Turley, says that the law professor's letter was making the claim that as long as even one person is deported, then it's okay. There was no such claim in the letter, which I know very well. Yeah, there was certainly no implication in the letter that all you would have to do is deport one. The point the letter makes is that the president is fully spending all the enforcement resources that Congress has provided. But the president is not a magician. He can't spend resources he doesn't have. And that's why that example is very different from the ones that have been hypothesized.
Thank you very much.
Common sense and just that if a person's in the country illegally, and on top of that they commit a serious crime, they should be deported?
Yes, I think it's beyond common sense. I think we have a duty to protect people.
And the law, of course, requires that. And it's just too often not being followed in an effective way.
Senator, may I just add that I think Sheriff Clark has just made one of the strongest arguments in favor of the president's executive actions. The main point of the new prosecutorial priorities is to be able to focus resources on precisely the individuals whom he is describing, and hopefully it will have that effect. I don't know in this case why the state authorities released a person. If it was while the person was pending trial, they must have thought that it's safe to release him, so I'm not sure why the onus is shifting to ICE. But that aside, this is what the administration is trying to accomplish.
Well, this isn't a matter of discretion, Mr. Legomsky. I know you served with the USCIS. This part of it is mandatory, is the point I'm raising. We're entering into an utterly lawless system here. Nothing Congress passes, apparently, has the ability to be effectuated in reality. That's the problem. Congress will pass things, and they don't happen. We mandated a fence, 700 miles. Doesn't happen. We said there should be an exit-entry visa, which the 9/11 Commission has hammered us for not completing as law required, and it still hasn't been completed. Are you aware that the group that you worked with, the Federation of Government Employees who represent USCIS, has opposed this bill vigorously?
Yes.
And say it will not work and is not helpful?
Well, this is the very same group whom some people are suggesting will refuse to obey the Secretary's instruction to exercise discretion and will instead rubber stamp these cases. So
well, let me ask you about discretion. That's Professor Eastman, in his testimony before the House on discretion, says there's nothing in the memo to suggest that immigration officials can do anything other than grant deferred action to those meeting the defined eligibility criteria. Indeed, the overpowering tone of the memo is one of woe to line immigration officers who do not act as the memo tells them they should, a point that has been admitted by the Department of Homeland Security officials in testimony before the House. And in the House, the Chairman Goodlatte of the House Judiciary Committee said, quote, DHS has admitted to the Judiciary Committee if an alien applies and meets the DACA eligibility criteria, they will receive deferred action. In reality, the immigration officials do not have discretion to deny DACA applications if the applicants meet these criteria. And I think, Professor Rosencrantz, you indicated there might be an illusory thing here. Isn't that proof that it is illusory discretion? In fact, it's mandatory.
Absolutely.
Well, the memo says precisely the opposite, Senator, with respect. It says that these are cases that, quote, present no other factors that, in the exercise of discretion, make the grant of deferred action inappropriate. And then at that very end, there's even more explicit wording. The ultimate judgment as to whether an immigrant is granted deferred action will be determined on a case-by-case basis. So the memo refers explicitly to discretion.
Senator,
well, we said we're going to do an exit entry visa, and it's not. The truth is that the officials are going to approve the people if it meets the DACA or meets the memorandum standards.
The important thing to notice is that it flips the presumption, right? The presumption is that the law will not be enforced, and somebody might have discretion to enforce the law in a particular case, but this is turning prosecutorial discretion on its head. The presumption in general is that law will be enforced, and discretion will be used to to create an exception to the rule. Here, the enforcement is clearly going to be the exception to the rule if it happens at all.
Except that the entire deferred action memo is the exception, right? The norm is that you do get deported if you fall within one of the deportability grounds. This memo lays out an exception. If you meet the following criteria, then USCIS officials will have the discretion on a case-by-case basis to defer
Well, just briefly, if the people don't meet the standards and somebody does get turned down, well, the projection is a little less than half the people, 5 million out of 11. What if somebody is turned down? Are they going to be deported?
Generally, I would think yes, if they bring their presence to the attention of the enforcement authorities and if it fits within the prosecutorial discretion priorities, then I can't think of any reason that ICE would not.
Well, they're not going to be deported. They're not. The only ones that are being deported today